as an attorney, instead of finding myself with a question that literally I can find no answer to, and then how do I advise my client, whether my client's the trustee, the beneficiary, or the creator of the trust, how do I advise them when I can find no rule? This sets out a series of default rules. I'm Randy Nelson. I'm a partner in the Milwaukee law firm of Weiss Brzezowski Brady. I was the chair of the Joint Committee of the State Bar and the Bankers Association for the Wisconsin Uniform Principal and Income Act, and was a member of the Joint Committee for the Wisconsin Trust Code. The problem that Wisconsin had, and actually that most states have or had, is a lack of detailed law dealing with the administration of trusts. And it's because of that lack of clear rules that the Uniform Laws Commission created the Uniform Trust Code as a basis for states to either clarify existing law or create new law where none really existed. And there were many, many areas in trust administration where, as a practitioner, you would face a question that you know comes up all the time, and you'd look for the black letter law that tells you what the answer is, and in Wisconsin and most states you would find nothing. And so the Wisconsin Trust Code is designed to fill in those blanks. In some cases it's designed to change Wisconsin law, and in other cases our committee actually changed the uniform law so that it would be consistent with our existing Wisconsin law, because we liked our Wisconsin law as it was and did not want the new trust code to change that. One of the keys of the Wisconsin Trust Code is that it establishes default rules. That is, it sets out, here's the rules that apply if the trust document is silent. But most of the rules that are spelled out in the trust code can be modified by the attorney as the drafter of the trust document. It really causes us as attorneys to understand what these default rules are, determine whether these are things that our clients are going to want, or whether our clients' objectives may sometimes be inconsistent with those rules, and therefore as drafters we need to modify the trust document. So it does add another issue for us as planners to deal with in trying to accomplish our clients' objectives. One of the most significant default rules is in Section 813, which has to do with the trustee's duty to inform and report to the beneficiaries of the trust. And that's going to be an area that, as practitioners, we're going to really have to understand those rules in great detail and determine when it's appropriate to discuss those rules with the client to decide, or to help the client decide, whether they want to make a change to those rules. July 1st of 2014 was the effective date. It was passed last December, but we had a delayed effective date so that attorneys would have some time to review the statute and prepare for the July 1st effective date. One of the main resources would be the actual Uniform Trust Code as it was approved by the Uniform Laws Committee. And the reason that's an important source or resource is that it includes not just the suggested statute, but includes commentary, which adds explanation to what the statute is trying to accomplish, why it's there, what the philosophy was. Now, attorneys are going to have to be very careful, because in our Wisconsin Trust Code, we did not always follow the Uniform Trust Code. So before relying on one of those comments, the attorney is really going to need to compare the Wisconsin Trust Code provision to the Uniform Trust Code provision.